distinguished guests, ladies and gentlemen, a very good afternoon. My name is Srishti Joshi, a proud alumni of our Department of Law, NEHU, and as your host for this afternoon, it is with absolute honor I take this opportunity to welcome our esteemed guests present with us for this program. His Lordship, Honorable Mr. Justice Vishwanath Sumadar, the Honorable Chief Justice, High Court of Meghalaya, Honorable Vice Chancellor Sir, Professor S.K. Srivastava, respected Pro Vice Chancellor Sir, Professor H. Lamin, respected Deans of Schools and Faculty of NEHU, respected Registrar Sir, Dr. J.N. Nayak, officials of the High Court of Meghalaya, and our students and online participants. It is our pleasure to extend a very warm welcome to you all here today, and as we celebrate the 71st Constitution Day. It is our privilege and honor to have you all amongst us, and we appreciate your taking time off your busy schedules to join us today. To begin the program, I would like to invite our respected Registrar Sir, Dr. J.N. Nayak, to deliver our welcome speech. Ladies and gentlemen, Dr. J.N. Nayak.
Namaskar. A very good afternoon to all. Honorable Mr. Justice Vishwanath Sumadarji, Chief Justice, High Court of Meghalaya, Chief Guest of this program, Honorable Vice Chancellor, Professor S.K. Srivastava, Pro Vice Chancellor, Professor Henry Lamin, Registrar General, Meghalaya High Court, Law Officer, Protocol Officer, other officials from High Court of Meghalaya, Honorable Deans, Professor Raut, Head of the Department Law, Professor Mujika, Convener of this program, faculty members, officers, staff of NEHU. In fact, it is a proud privilege for all of us that we are celebrating the Constitution Day, and we are celebrating this with none other than the Chief Justice of Meghalaya High Court. I, on my behalf and on behalf of the university, extend a very warm welcome to you, sir. With this, we welcome our Vice Chancellor, Pro Vice Chancellor, other faculty members, deans, and officials from Meghalaya High Court. In this beautiful afternoon, when the sun is playing hide and seek with the clouds, with the merry chime of church bells, with the rhythmic music of the air passing through pine groups, NEHU stands tall over the years, depicting come hither to learn and go thither to serve. With this, NEHU stands as the premier institution of the country in this part, in this region of the country. Sir, this is your first visit to NEHU, and we are all extremely happy to welcome you in our campus, because this is one of the auspicious days when we can have a galaxy of personalities, and especially a personality like you, who is heading the judiciary system in this part of the country. On this Constitution Day, we know that so many things have happened. I'll just give a very small brief on this issue. On 26th November 1949, the Constituent Assembly of India adopted the Constitution of India, and it came into effect on 26th January 1950. It is also known as the Samvidhan Divas, National Law Day. The Ministry of Social Justice and Empowerment on 19th November 2015 notified the decision of Government of India to celebrate the 26th day of November every year as Constitution Day to promote constitutional values among the citizens. The members of the Constituent Assembly signed two handwritten copies of the document on 24 January 1950. 2 days later, it became the law of the land. That is the reason why it is also celebrated as the mark of tribute to the India's first law minister, B.R. Ambedkar, who played a pivotal role in drafting the Indian Constitution. The Constitution is a set of written principles and precedents of Government of India that frames fundamental political principles, procedures, rights, directive principles, restrictions, and duties of the government and citizens of the country. With this, I once again welcome all of you. Thank you. Thank you, one and all.
Thank you, Dr. Nayak, for your wonderful opening speech. Moving forward, I take this opportunity to welcome our chief guest for today, His Lordship, Honorable Mr. Justice Vishwanath Somadar, the Honorable Chief Justice, High Court of Meghalaya. It is an honor and privilege to have him with us today. May I please call upon Honorable Vice Chancellor, sir, to present the memento to His Lordship. All right. May I call upon the students to present His Lordship with a token of appreciation. Thank you. Moving right along, it is now my pleasure to invite our nodal officer for the program, Professor J.J. Mozika, to introduce today's program for us.
A very good afternoon. His Lordship, Honorable Mr. Justice Vishwanath Somadar, the Honorable Chief Justice, High Court of Meghalaya, Honorable Vice Chancellor, Professor S.K. Srivastava, respected Pro Vice Chancellor, Professor Lamin, respected Registrar, Dr. J.N. Nayak, the Deans of the various schools in NEHU, faculty members from different departments, officers from the court, students, online participants, a very warm welcome once again. Our registrar sir has already welcomed our guests, and so I do not need to repeat, but still on behalf of the university, I will just express my gratefulness to His Lordship for having accepted our invitation so readily and gracing this occasion and being a part by blessing our students, our university. I will not speak much about the theme of the Constitution Day because our registrar sir has already introduced the subject. Just a little bit background of the 70th Constitution Day celebration, 70th anniversary of the Constitution Day. Last year, the government of India had decided to celebrate the 70th anniversary of the Indian Constitution, and that was supposed to be a year-long program starting from 26th of November 2019 and culminating today, that is the 26th of November 2020. And the prime focus of the year-long celebration was on the fundamental duties. The aim of the government of India was to create a nationwide awareness among the citizens the youth of our country about the importance of the fundamental duties. And the aim and objective was to organize various programs throughout the year to, in an endeavor to create awareness about the fundamental duties amongst the citizens. But in the meantime, the COVID, the pandemic intervened, and we, as far as possible on online platform, whatever programs were organized throughout the country, we could not have physical programs to that extent. But still, I feel that various universities and the national coordinating university was Delhi National Law University, and there were 25 state universities which were coordinating, and our university in the Northeast was identified to cater to the Northeastern region, and the our Honorable Vice Chancellor was, you can say, I will say that I am grateful that I was nominated as the nodal officer for the Northeastern region, representing our university, and my task will be over today, perhaps, but not in that sense. We owe responsibility towards the country, towards our institution forever, and we cannot say that there is an end, but only for the purpose of the year-long celebration, my task comes to an end after we finish this program. Uh, Now, since the thrust of the program was on fundamental duties, I would like to mention that the 76th Amendment of our Constitution introduced Part 4A of the Constitution, and through which Article 51A was inserted in our Constitution. And initially, the Part 4A contains 10 fundamental duties, and in 2002, the right to education that was also expressed in the form of a fundamental duty, and it was inserted in the last clause, clause L, perhaps. K, yes. So that was in 2002. Now, a question arises in our mind that why is it that the fundamental duties chapter was not introduced at the time when we adopted our constitution? I found, while reading some material, I found there is a observation by noted jurist C.K. Allen in his book Law in the Making. He makes an observation and he differentiates between Eastern jurisprudence and Western jurisprudence. And he observes that in India, where we follow the Eastern jurisprudence, our focus is on dharma. We talk about kartavya. We talk about not our rights first, but our duties first. Kartavya or dharma means our obligations. We focus on our rights. And that is why perhaps our constitution makers felt it not necessary to include the fundamental duties at the time of the adoption of the constitution. Western jurisprudence, on the other hand, focuses on rights first. There are many jurists who talk about rights and duties are correlative. But first come rights in Western jurisprudence. They talk about rights, but then they say they are corresponded by duties. Where there is a right, there will be a duty. But the prime focus is on rights in the Western jurisprudence. And that is why perhaps Western constitutions focused more on rights. American Constitution focuses on the Bill of Rights through the amendments, and but maybe there were certain historical processes going on in our constitution, in our country after the adoption of the constitution, There were so many diversities, there were so many religious, linguistic, and other differences, and people perhaps forgot that they owe to the country, to the citizens, to their fellow citizens. And that is why perhaps it was felt necessary to introduce the 76th Amendment through Part 4 of the Constitution. We will be having a reading of the preamble and the fundamental duties, and so I will not dwell much on all those aspects. I will give, we just hope we have a very good interactive session with His Lordship. His Lordship has clearly, like he has mentioned it to me twice, that he wants an interactive session where we can share our views and give our opinions. Thank you very much.
Thank you, Professor Mozika. Ladies and gentlemen, just a quick housekeeping note before I move along. May I please request you to keep your mobile phones on silent mode just to avoid any interruption. Thank you. I would now like to invite Dr. A.K. Singh for the reading of the preamble, followed by Dr. Naveen Kumar.
A very good afternoon to you all. So now I'm going to read the preamble of the Constitution, which is key of the Constitution. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. धन्यवाद.
May I now invite Dr. Naveen Kumar for the reading of the fundamental duties.
A very good afternoon to all. I'm going to read fundamental duties. Article 51A. It shall be the duty of every citizen of India to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. Clause B, to cherish and follow the noble ideals which inspired our national struggle for freedom. Clause C, to uphold and protect the sovereignty, unity, and integrity of India. Clause D, to defend the country and render national service when called upon to do so. Clause E, to promote harmony and the spirit of common brotherhood amongst all of the people of India. Transcending religious, linguistic, and regional or sectional diversities. To renounce practices derogatory to the dignity of the woman. Clause F, to value and preserve the rich heritage of our composite culture. Clause G, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife. And to have compassion for living creatures. Clause H, to develop the scientific temper, humanism, and the spirit of inquiry and reform. Clause I, to safeguard public property and to abjure violence. Clause J, to strive towards excellence in all spheres of individual and collective activity. So that nation constantly rises to higher levels of endeavor and achievement. Clause K, who is a parent or guardian to provide opportunity for education to his child. Or, as the case may be, ward between the age of 6 and 14 years. Thank you.
Thank you. Ladies and gentlemen, I now request our Pro Vice Chancellor, Sir, Professor H. Lamin, to deliver his address.
Today is a special day in which we have the morning session and an afternoon session. Thank you for inviting me to share my thoughts amidst the learned person who have come from the judiciary, especially our Chief Justice, who is Honorable Mr. Justice Biswanath Sumandar. I think, sir, this is your first time to visit our institution. Welcome. And his team, the deans, teachers, the organizer from law department who have taken this initiative to take this program, and particularly to involve all of us from the administration. We have the Vice Chancellor who spared his valuable time here, the registrar who have welcomed us, to all who have participated for this program. And today is a day in which we remember in particular our Constitution. This Constitution has been framed quite a number of times for nearly 2 years and few months. They could materialize it and it becomes as it is of today. Well, dear friends, I will not deliver too much what is written in the Constitution because time will not allow us. And few minutes ago, we have been reciting the duties which has been enshrined in our Constitution. Besides the Preamble, it has also enlightened the fundamental duties as we citizens are living in this vast country. My point of conduct today is just a few points to share with you. That is These are, I have tried to mention few of them. Those who have come across, please don't try to remark immediately in front of me by raising your hand and say, no, it is not. Anyway, I'll take it as follows. Our Indian Constitution was formed in 1946, and it is considered to be the supreme book which applies to every citizen in this country, a supreme book which is applied to every citizen in this country. And it is, of course, legally enforced on the date today, that is 26th January 1956. And we celebrate it on this day after much thought given by our Prime Minister, who has realized and found out that why can't we not put a day for this day to be remembered for all what our forefathers have contributed to us. I'll take another note. I think this constitution of our country today is the world's longest written constitution with 448 articles divided into 28 parts. So those who are in the judicial, they must have already well versed with this, because our country is having three heads: the legislature, the executive part, and the judiciary part. So these three heads, like Ashoka heads, always play a role how to run this vast country. And for the information of all those who are not aware, it is handwritten by Prem Narayan Rai Sada. This is a person who has initiated it by writing it in hand. Later on, they have realized it, that we have to put it in a type form, not with handwritten. It will be too lengthy. And also the original copy, I am sure most of our friends, they know that it has been done in Hindi and in English. Why English? Because they have realized, our forefathers have realized, that in India, besides all the Hindi belt and some other regions are not well acquainted with the Hindi. Now a lot of effort has been made, and I think our young children have already acquired a lot of knowledge about Hindi. I think time will come, like this morning when we recite the preamble. In the first instances, what we have joined with the center is that all in Hindi. I really feel pity of myself that I can't speak Hindi, broken Hindi. I can speak in the Bara Bazaar or in any other commercial center, but not to provide a speech or anything. Well, and for your information, this preamble or this constitution has been done by an artistic work in which we admired it. That was from Shantini Ketan, which has been decorated every page. If you look in this constitution, you will find out that it is well decorated with a very artistic. This shows how much attention our forefathers have come across to look the importance of this constitution. Well, as I have said earlier, this constitution has come into an active part after 2 years, 11 months, 18 days. That was the effort made by our forefathers at the time when they constituted. And of course, there were more than 2,000 amendments before it is being enforced or before it is being implemented. This shows that they are very, very cautious. What will be the impact of this constitution in the day-to-day life affair of this vast country? Well, I really admire their greatness for their work they have done. And for the information of many members, you see the concept in this constitution of the 5 years plan was taken from USSR, and the directive principles in which we always see about how the socio-economic impact on the life of the people is being taken from Ireland. This is a country in which we are quite acquainted now after they have been recognized as a sovereign of itself. Well, we know that in the Constitution it has been enshrined the word liberty, fraternity. All these terms, liberty and fraternity, were taken from the French Constitution. I hope some of my friends are already aware. Anyway, I will come into the conclusion that our country, India, and USA, which is just recently finished their election, which is of course still now we have seen how the democracy play a role even in that highly developed country like USA, or even in our country, how it plays that the rule of the people which has been mentioned in the Constitution, it mentions like this: we the people. Means everything it is of the people, for the people, that this constitution has been made. That's why it starts, we the people. I congratulate to all our founders who have done much effort to see that this ancient constitution of this country will prevail in all the years to come, to make, as we have recited few minutes ago, how our duty is to go along with the rights that has been enshrined in our constitution. I am sure our Chief Justice will enlighten us in many areas in a more educative way that many of us are not aware. We will try to learn and interrogate, as rightly said by the nodal officer in his presence, to get some clarification or interaction. This is part of life, which is in day-to-day affair. I believe that by keeping this constitution, though it has reached now 104 amendments, I am sure in the years to come there will be more amendments according to the demand of time, according to the demand of the people, which will be changed from time to time. So with these few words, I would like to end up, and thanks to the organizer and to his lordship who has spent his valuable time to come and visit us here, to see around the scenario of NEHU, and also to see sometimes the feedback which our people give to the public. What is NEHU? Well, I think that is part of life. Sometimes yes, sometimes no, sometimes for, sometimes are against. This is the way of life. We live in a world of where there are many waves, where there are many ups and downs. I wish the program will go smoothly with His Eminence present here to enlighten us. Thank you. Jai Hind, Metala Kuble.
Thank you very much, Professor Lamin, for your address. Moving forward, I take this opportunity to invite Honorable Vice Chancellor Sir, Professor S.K. Srivastava, to deliver his address.
Namaskar, very good afternoon to you all. The very respected His Lordship, Honorable Mr. Justice Vishwanath Sumaderji, Honorable Chief Justice of High Court of Meghalaya, Pro Vice Chancellor, my esteemed deans, the registrar, the faculty members, and officers of the Honorable High Court of Meghalaya, officers of NEHU, my dear, most dear students, and dear participants who have joined this program online. I join my very esteemed colleagues, the preceding speakers, esteemed colleagues in welcoming your Lordship, sir, in our midst on this very, very auspicious day. That is the 71st Constitution Day celebration, great occasion, and what a great day that it is being celebrated in your very auspicious presence, sir. We have just participated in the reading of our preamble and the fundamental duties of the Constitution of India in his auspicious presence of His Lordship. It's a fantastic moment for each one of us. And I think you all are earnestly looking forward to hear His Lordship's speaking on that structure of Indian Constitution, and of course converting the whole session into a very interactive, lively session. So I wouldn't say much, except that I should also talk very briefly about the Department of Law. Your Lordship, sir, I'm happy to share with you that the Department of Law, which was established about 15 years ago in the year 2005, really full of activities. We have 5 years integrated BLLB course. Here LLM 2 years also going on. We have PhD program also in law, and the very contemporary relevant themes and topics. My esteemed colleagues are doing research in those areas. We have about 30 research scholars, and of course, we have our alumni also. They have done well. They are still doing well in different streams, of their career, profession. Some of them are law officers, judicial magistrates. Your Lordships are in autonomous bodies. They are there, and they are also further pursuing their other professional career. And I am proud to say that my colleagues from the Department of Law, they are very sincere, hardworking, and always available to the students in sorting out all those academic and other issues. And I mean, I'll seek very humbly maybe appointment with you, sir, regarding sorting out certain issues related with the establishment of Bar Council of PCI here, because our students have to, I think, go to Guwahati to get those certifications and all done, approvals. So that will facilitate our own students. This is a brief about the Department of Law and the university that was established in 1973 under our Act of Parliament. So already 47 years we have been through, and it's a center of academic excellence. And I think during the last, I would say 5-6 years, not a single day has been lost, in any kind of academic disturbance. Of course, as we all have our democratic rights, so I think they should also express in one way or the other. But all said and done, they have been very, amicably sorted out. And I'll just, take half a minute or so here. We are just, read about the fundamental duties. And in the forenoon session, Your Lordship, sir, Honorable President of India led the reading of Preamble, and we also held a program at 11 o'clock. It was for about 15-20 minutes or so. So we have completed that, and this is another very important activities in your auspicious presence. And मैं ये कहना चाहूँगा, जैसे जब हम लोग ड्यूटीज की बात करते हैं, तो एक मेरे मस्तिष्क में एक प्रश्न भी आता है कि वे देश ने हमको दिया है सब कुछ, देश ने हमको दिया है सब कुछ, हम भी तो कुछ देना सीखें. I think we always are conscious of their rights. We should be. I mean, the Constitution of India and its very preamble, the key words, we talk about, I think, justice, liberty, equality, and fraternity. And in the main text of our Indian Constitution, there are also mention of a host of fundamental rights and so on. So I think all that they are definitely required for every citizen of the country. So duties also, we should be conscious of it, and we should do our duty not as a formality, but to the best of our sincerity, our energy, our efforts, and so on in serving the cause of the people here. Or as a citizen, I am very proud of the judiciary of my country, which is a great institution, the whole judicial process, and I'm proud to say that, and now that the host of several socio-economic, political, constitutional matters have been very amicably, very actively, sorted out, and there have been landmark judgments. So I think this is very rare, and एक भारत के नागरिक के रूप में मैं इसको बहुत ही गर्वान्वित अनुभव करता हूँ. और इस संविधान दिवस के शुभ अवसर पर और हमारे माननीय मुख्य न्यायाधीश जी की उपस्थिति में आप सभी का हार्दिक अभिनंदन, आप सभी को अनेक शुभकामनाएं. And of course now I think we are looking forward to hear your lordship, sir. So I think now the floor will be yours, and we look forward to learn a lot. At least I, being a science student, I look forward to learn a great deal from interaction and your addresses. So thank you once again, and special thanks to your lordship, sir, for taking your valuable time for this great function, and be with the NEHU fraternity. We feel great in your presence. So thank you very much. Jai Hind, namaskar.
Thank you very much, Honorable Vice Chancellor, sir, for your address. May I now take this opportunity with great honor to invite our chief guest for today, His Lordship Honorable Mr. Justice Vishwanath Sumadar, the Honorable Chief Justice, High Court of Meghalaya, to grace the podium and deliver his address before the August gathering. Ladies and gentlemen, please join me in welcoming His Lordship.
Sit down. Learned Vice Chancellor, learned Pro Vice Chancellor, learned Deans of the various faculties, learned Registrar of this university, faculty members, registrars and officials of Meghalaya High Court present in the audience, officials of this university, students and members of the alumni if they are here, and all those who have gathered today, the Constitution Day, for this afternoon session. A very good afternoon to you. When I was approached by the professor of law, I had made it very clear to her that I would like to have it as an interactive session. But more importantly, I told her that I would like to speak with regard to the structure of the Constitution. But before I proceed with all that, when I was listening to the Vice Chancellor, he said that he is a student of science. I presume that that must have been noted in the year 1977. Someone must have heard him in 1977. Can you tell me why am I making this comment? Well, you don't have to guess. I'll give you an answer. If I'm not mistaken, Part 4A came by way of an amendment to the Constitution in 1977. Please check if I'm wrong with the fact. And in Part 4A, which introduces Article 51A, there is a clause, Clause H, and I'm going to repeat, you all read it aloud. To develop the scientific temper. So, even the Constitution wants a man of science, or a man, or a woman, or to be gender neutral, a human being, to have scientific temper. So I think the Vice Chancellor was heard even before he spoke. In the morning, I was addressing our High Court, and I think the head of the Department of Law was present.
I had in my address emphasized on the soul of. Can we have that noise outside to be switched? Some machine. What is the soul of the Constitution of India? The soul of the Constitution of India is its preamble. If one reads only a few lines, and you all have just read the preamble aloud, we all stood up. The preamble reveals the soul of the citizens of our country, because the written words begin with the very most significant expression, and that expression is "we the people of India." The soul of the individual citizen is expressed in most eloquent manner in the preamble. And if we understand, if we need to understand the basic structure of the Constitution, we need to only focus on the preamble, because the soul of the nation or the citizens which comprise it, because the nation means nothing unless it is with the citizens. And the citizens speak through those few words only. So, the basic structure of the Constitution is given its outline or its contours through its preamble. What is the most significant aspect can be understood, and one must also say, as a lawyer, I always told my colleagues, my friends, and whoever, I had learnt it very early in my professional life, that you do not need to mug up those sections and articles in order to understand the law. You must know how to look up the law and where to look up the law. So when you look up the Constitution, which is a written document, and I must say this, that this is where we make a departure from the legacy of the past, because we were governed by the Britishers, whose understanding of rule of law need not be discussed, but they never had and they do not have a written constitution. The departure was when the Constituent Assembly was formed, and it adopted the Constitution, the Constituent Assembly, on this very day, as far back as in 1949. The very first words in the article, which forms the beginning words of the Constitution, is India, that is Bharat, shall be a union of states. The very first expression of this country, that is Bharat, is a recognition of its federal structure. And that is precisely what I wish to speak to you about today. What is this federal structure, and why is it important for us to understand this federal structure as opposed to a unitary structure. The concept of federalism, which India has adopted, has its genesis several hundred years before India's constitution came into effect through another written constitution, the American Constitution. The recognition of the concept of one country comprising of federation of states has its roots there. But India has obviously in 1949 and 50 made certain departures from the American Constitution. May I also digress to say that Indian Constitution is based on the first principles of several constitutions, including the unwritten Constitution of Great Britain, the written Constitution of USA, the French Constitution, and selected constitutions was, I remember, a book that I read way back when I was doing my graduation. And in those days, the 5-year law course had not come into existence. I would also request the Vice Chancellor to think about introducing the 3-year law course also, because there is a sizable amount of people who are eager to take up law as a postgraduate post after obtaining BSc BCom or BSc, as we all did. So the 3-year law course can also be a viable option today. 3-year law course, but I'm not on that. Yes, so you must also do a 3-year course. It's very, I'll tell you, it's very important, because what is happening with 5-year law courses, I must say that these national law schools, very few people are going into litigation. They are going into other branches like corporate law or legal advisory, but not into core litigation. And if you do not litigate, if you don't go into court practices, then with all your degrees and all, you, according to me, you are not being able to do justice to the professional expertise that you have actually. Of course, unless you go to academics, that's a different story altogether. Now coming back to the concept of federalism. You know, there are differences of the concept of federalism between USA and India. I need not go into a comparative study of the two, but what is important for us to know is how federalism is recognized by the Indian constitutional scheme. If one opens the contents page of the Constitution, and I did not trouble you with all this, you'd see that the Constitution is divided into several parts, and each part has some chapters in it. It's a written Constitution, so why not look at the written document in order to understand the concepts? If we look at part 1 of the Indian Constitution, of course, you are discussing about part 4, part 4A. We'll talk about all that later. You would find that the constitutional framers had began with the concept of India, that is Bharat, being a federation of states, which they said shall be a union of states. So a recognition of states come at the very outset of this written document. So what will comprise of the union and its territories are defined in part 1. Part 1 Then part 2 dwells with citizenship. Can you tell me anywhere in the Constitution we have about fundamental rights, legal rights? You are legal experts here, sitting here, and students also. Where is the expression that right to vote is a fundamental right? You will not find it there. The reason is so simple. No one asks this question. The reason why right to vote is not there is the very fact that if you look at the preamble, it said, we the people. The people can, the first principles of democracy, for the people, by the people, of the people, signifies it is the people who are deciding on the constitution. So the right to vote is already embedded into it. I will not dwell upon fundamental rights, which is again the part of part 1, because sorry, it's part 3, my mistake. Fundamental rights, because a lot has been spoken about fundamental rights, but much less has been spoken about part 4 and part 4A, because they are directive principles of state policy and fundamental duties. We all know that directive principles cannot be enforced through court of law. They are not non-justiciable. But fundamental duties, if I have a legal right which I seek enforcement, the state can say, don't you have a corresponding obligation? And that obligation finds its place through fundamental duties, which I think this government is highlighting upon, and rightly so. But I am not on fundamental rights and fundamental duties. I am on a more fundamental principle of federalism. Now, how do we look at this constitution? And we're only going through 3-4 pages. I can understand that federalism is palpable on the face of the constitution, because the constitution seeks to divide the union and the state. This is how it starts to divide the union and the states. Part 5 deals with the union. Broadly, the union comprises of the executive, the parliament, and the union judiciary. Of course, we'll not talk about the legislative powers of the president, that is also not there. But what is significant is, in the federal structure, we have a dual system. And in the dual system, we have a central or the federal authorities of the political executive, which is known as in the constitution, I'm just quoting, part 5 is the union, chapter 1 is the executive, the president and vice president, the council of ministers, which of course is headed by the prime minister, the attorney general, and so on. And then you have the union parliament. We, of course, I'm sure you know that we have a bicameral system. We have 2 houses. The House of Lords, as is in England, is known as the Rajya Sabha, and the House of Commons is known as the Lok Sabha. These are borrowed concepts from the Westminster model. I need not trouble you on that. But there is a union parliament. So let me make this comparison. If there is a political executive headed by the president and the vice president and the council of ministers in the center. What is the corresponding uh, power and authority of a state? Well, you have the governor heading the political executive, which comprises of the council of ministers headed by the chief minister. So in one hand, you have the political executive of the center, which is prime minister and the council of ministers with the symbolic head of the Rashtrapati on top. And in the state, we have the governor, you have the chief minister, the council of ministers in the state political, state executive. Now, if you look at the legislature or the legislative system in our country, you'd find similarly, you'd find the parliament comprising of the Lok Sabha and the Rajya Sabha, the two houses of parliament, so far as the center is concerned. And the state similarly, I think Mr. Srivastav comes from UP. So they have two houses of parliament there, which is known as the Legislative Council and the Legislative Assembly. Some of the states have abolished the Legislative Council, but some still have the Legislative Council. So, what is Lok Sabha to the union system is the Legislative Assembly to the state system. What is the Rajya Sabha to the union system is the Legislative Council in the state system. So now we have an idea of the union, political executive, vis-a-vis the state political executive. The Prime Minister is on the top of the heap insofar as the Council of Ministers who are headed by the Prime Minister, with obviously the symbolic head of Rashtrapati and the Uparashtrapati on the very top. But we have even in the state, similarly, the governor and heading the political executive of the state, which is the Council of Ministers headed by the Mukhya Mantri or the Chief Minister. The Parliament similarly, you have the Lok Sabha and the Rajya Sabha, and you have the Legislative Council and the Legislative Assembly. You have speakers in both. And then comes the judiciary. The Union Judiciary is known as the Supreme Court of India, often referred to as the apex court for reasons I don't know why. The Supreme Court is always the supreme. By adding words like apex doesn't make it more supreme or less supreme. And what is the apex court? If you look at the federal structure, then as much as Supreme Court is the apex court of the country, the apex court of every state is the High Court. So, the High Court is the state's apex court. Every state has a High Court. Whether there is a principal seat or not is inconsequential, because even a few years ago, Meghalaya was under the jurisdiction of Guwahati High Court with the bench functioning. There are many other high courts, I can name a few, which control or exercises jurisdiction over other states. Like Bombay has Goa, Madras has Pondicherry, Calcutta has Andaman and Nicobar Islands, Kerala has Lakshadweep, so on and so forth. Guwahati has 4 states. Punjab and Haryana unique. It has Punjab, Haryana and Chandigarh as a union territory. So the jurisdiction is exercised by the High Court, and it is the apex court of the state. We keep on calling the Supreme Court apex court, but we do not call the High Court as the apex court of the state. But obviously, it is the apex court of the state, but there is something very, very significant here, and I must request all of you to look into the Constitution. The Prime Minister has certain powers which A chief minister does not have. These are powers in the union list. I did not bother you. But the prime minister has no administrative superintendence over the chief minister, unless of course an emergency situation arises. This is because the doctrine of federalism is recognized by the Indian constitution, and the state is governed, is self-governed, barring a few significant matters which only the center has, for example, defense, for example, external affairs, to name a few. But it is like a self-governing system. The prime minister cannot tell any chief minister, do this, don't do this, unless of course there are certain statute laws. So this recognizes the first principles of federalism, that there are dual system of governance, each self-governing, without of course conflict. If there is a conflict, then the judicial system comes. For example, as I said, that there is an executive, there is a parliament or a legislature, and there is a judiciary. There is a speaker sitting in Delhi, the speaker of the Lok Sabha. The speaker cannot pick up his phone and call up the speaker of the Legislative Assembly of Meghalaya and say, let's do this or don't do that. There is no administration. Although coincidentally, you have had a person who became speaker of the Lok Sabha, very respected. The interesting part is the judiciary. The Supreme Court is the last court of appeal for the country. And you go there as last resort when you have exhausted all the high court or all the other court forums. But not all matters can be taken up by the Supreme Court as a matter of right. You have all heard about the term SLP. What is the full form of SLP? Special leave. Special leave petition means that you are seeking leave of the Supreme Court to move an appeal from an order of the High Court. There are certain matters where you can approach the Supreme Court as a matter of right. But SLP is not a matter of right, it is a matter of leave. If you can grant leave, if you are granted leave, your matters will be taken up. So Supreme Court is the last court of appeal, but it is not necessarily the court where you can approach as a matter of right. It is a matter of discretion of the Supreme Court to take up certain matters. Of course, there are matters which the Supreme Court by law are mandated to take up appeals. These are statutory appeals and so on and so forth. I did not go into it. But what is of significance is that unlike the high courts of the state, which exercises administrative and judicial superintendence over the court subordinate to it. As you know, every high court of a state exercises its jurisdiction over the district courts and the court subordinate to it. The similar provision of Article 235 of the Constitution, which allows superintendence over the high courts, or similar powers under Article 227, that is judicial superintendence, it is not there in so far as the power of the Supreme Court is concerned. In other words, the Supreme Court does not exercise power of administrative superintendence over the high courts. Why? Again, the answer is so simple. If you look at the basic structure of the Indian Constitution, the reason why the Supreme Court cannot exercise administrative superintendence over the High Court is the constitutional framers and draftsmen's conscious recognition to the federal structure. The federal structure of the Indian Constitution forbids each of these institutions from the center dominating the institutions of the state, leaving them to govern themselves of their own, subject to obviously conflict resolution through the due process of law. There cannot be, of course, having said that, I must also say that the Constitution also mandates that the Supreme Court will have the last say insofar as transfers of judges are concerned, elevation and all. But administrative superintendence, in the manner in which the High Courts exercise power over its subordinate court, that same equivalent power is not there in the Constitution so far as Supreme Court is concerned vis-a-vis the High Court. Just like I said that the Prime Minister cannot pick up the phone and tell the Chief Minister do this or do that, the Chief Justice of India also cannot administratively supervise the High Court by calling up a Chief Justice and saying that do this or don't do that. See, as also the Speaker of the Legislature, the Parliament, the Lok Sabha cannot pick up the phone and call up the State Legislative Speaker. This understanding of our Constitution is required. It is only when we understand this concept of federalism, we will understand that there is a need for cooperation amongst the Federation of States. And that cooperation amongst the Federation of States is very important for a nation to thrive. If one state decides to close the gates of its doors to another state, an adjoining state, what will happen to that other state? There has to be a healthy relationship between the states inter se and the center vis-a-vis the states. The concept comes from cooperative federalism. There has to be cooperation amongst the various players of the federal structure. And various players of the federal structure would mean that not only the center and the state, but state and of course states individually with the center and cooperation amongst all of them as players are very significant, but without trampling on each of their jurisdiction. This is almost like the concept of live and let live. The reason is, if this healthy practice of cooperative federalism is not observed, then you would find that one state is treated in a different manner as another state, and that itself will negate the concept of equality. And as the equality word is suffixed by three expressions, then equality is suffixed by equality of, you see, this is of status and of opportunity through two ways. So if a particular state is treated in a different manner as another state, then that other state is at a disadvantage. Now, everything that the preamble has said, every word that has been expressed, whether it is beginning with the word justice, by the way, social, economic and political, then liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and above all, fraternity, ensuring the dignity of the individual and unity and integrity of the nation. This very concept itself, when you read it with Article 1, India, that is Bharat, shall be a union of states, makes this country an example of what harmonious existence can be with multiple states functioning under the umbrella of union authority. The reason again would be that it is not possible for Meghalaya, I am just giving an abstract example, to have its own armed forces to protect its border from foreign invasion. It is not possible for Meghalaya to have embassies all over the world in order to maintain foreign relationships. It is not Meghalaya to have a currency system which will be different from the currency system of Rajasthan. So you need the union of federal government or the union government or the union judiciary or the parliament to take care of these issues. Defense, external affairs, currency, these are to name a few, as I said at the very outset. But what is very important is that every of these institutions should work in tandem with each other. There should not be any conflict, and this is where our attention should be in the preamble. The preamble by itself smooths all creases that are there. The Indian Constitution, initially when it was drafted and brought into force, it was thought to be rather an inflexible document. But I think we have crossed a century of amendments, and today the Constitution is known. When we were young, we were told that it is semi-flexible. But today I can say with some degree of confidence that it is one of the most flexible constitutions. A lot of amendments can take place. But having said that, I must say that one part of the Indian Constitution cannot be touched either by courts of law or the parliament or the political executive, and that is the basic structure. The basic structure document. How do you look at the basic structure? Read the preamble over and over again, read the Constitution, and you will have a clear idea of the basic. It is the soul of the nation, of citizens speaking through this preamble, which brings in the basic structure concept. Yes. I have thought that this would be an interactive session. I conceived this. So if there is any question amongst you, please feel free to ask me. And although my knowledge is extremely limited and my understanding of the Constitution may be below your expectation, I shall try in my humble way or endeavor to give some answers to your questions. Sit down and ask me.
Please introduce yourself, and I think you should give floor to the students also. Yeah, please. Yeah.
Article 32 was told that it is heart and soul. Because if you have all 24 articles starting from 12 to 35, this is redundant when the Supreme Court and High Court are because you have to adjust all the lower court. When the Supreme Court gives it after the time and money and lot of things are there. So thereby again we believe that Article 32 is the heart and soul, one physical and one spiritual. Because after sometimes in 1978, when A.K. Gopalan case was there, and Justice Fazal Ali dissented, and that dissentment became a law in 1978 in Maneka Gandhi case. Then we thought that
right to go abroad, right to environment, right to good air, and everything that available under Article 21. That time also we thought that now we shifted from 32 to 21, that become heart and soul of the Constitution. Thanks to you that as per your interpretation, and you brought that preamble is also soul of the Constitution, and you departed that physical part, and you have not talked that it is a heart and soul. It is a soul, because already in Kishan Bharati case they brought it, because this preamble what you are talking, that was the objective resolution of the Constitution. That was not a part of the Constitution. Only in 1973 that Kishan Bharati they thought that preamble is also a part of the Constitution. So I also only I defer. It is a soul, no doubt, but is it not a heart and soul of the Constitution?
Well, this is just a play of words. What is heart and what is soul? Unless you have a heart, you don't have a soul. Unless you have a soul, you don't have a heart. So it's not the question of whether it is heart or soul. It is the spirit of the individuals that is expressed through the preamble. And much as you talked about Keshavananda Bharati, I must say that notwithstanding the observations made by the Keshavananda Bharati, in much later after Keshavananda Bharati, this preamble was touched and there was an amendment. And this was the introduction of the word sovereign, socialist, secular, sorry, socialist,
It is 76.
70, after Keshavananda.
Yes, sir. Yes.
Now, court said that this was all right to amend. Was it all right to amend the constitution? I don't want to enter into the controversy. But when the framers had come with the concept of sovereign democratic republic, it should have not been touched according to my limited understanding. Having touched it, you are touching the soul of the constitution.
It is subsumed in that.
So we are not on the heart and soul. What I wanted to say that the spirit of the expectation of the citizens to find a voice, and the voice of the nation is expressed through this soul. Why the preamble was touched is not for me to say. The preamble was touched by the parliament and was ratified by the Supreme Court. Notwithstanding Keshavananda Bharati, because Keshavananda Bharati did not look at those words, socialist secular. It came in much later.
So I'll just intervene to just address the online participants. If they would like
Yes,
to
of
have
course.
any questions, any queries, the online participants, if you have any queries, any discussion.
We see Mr. Roy, Mr. Arya, any one of our participants online.
The online
Would
participants
like to interact with our His Lordship Chief Justice of Honorable High Court of Meghalaya. It's a golden opportunity. Please come in. Anyone? Or the students present here, and whatever you said about Atma, actually Mansa Vacha Karna, that should be the spirit, for performing our duties and also asking for our rights as well. The students ko bhi zara dekhiye.
Diganta, if any question, you all can unmute yourself, whoever wants to speak. Professor Chaturvedi.
Are we audible?
Romita.
Are we audible to them? But anyway, I think let's begin with our students and faculties. And kindly, be very brief to the point. It's not that your interaction should be like you have a queries and you have the Honorable Chief Justice here. Please.
Good evening.
I'm Celestine Sho, student of Law Department. Thank you for enlightening us more on federalism. I think in India we have a very unique concept of asymmetric federalism. And for example, federalism which addresses local context, geographical needs. Best example is like Jammu Kashmir, status of Jammu Kashmir earlier, the 6th schedule. And I just want to raise a question on a differential treatment to those states. Now, whether that concept of asymmetric federalism goes against the principle of equality or not.
Your question is based on a premise that there is differential treatment. That's a subject. That's your subjective assessment. I'm not going to comment on the subject. I would consider all states are treated equally, unless, of course, discrimination is brought to the forefront, and that has to be addressed by a court of law. You say discrimination, but that's your subjective view. How should I comment on a subjective view? You are free to say that it is discrimination. This is like, let me put it, a glass of water half filled. You look at it and say it's half empty. She looks at it and says half full. What should be my opinion on that? I would say, let's not look at it as half full glass or half full. Look at it as half glass.
I beg your pardon, Your Lordship, on the principle of equality, Your Lordship.
On principles of equality, all agencies, all states, all players should be treated equally. If there is discrimination, I'm standing in the podium, I cannot say there is a discrimination. You are alleging discrimination.
Not exactly, Your Lordship. You see, we have Article 14.
Yes. And what does Article 14 say?
Principle of equality.
No, it doesn't say principle. Let's read Article 14.
States shall not deny to any person equality of law or equality of opportunity of law within the territory of India.
Let's read.
Reasonable classification.
Patience, Honorable, our Chief Justice sir is just about to refer to that. So let's all hear and get more enlightened about this.
The state. The state could mean the center or the state, which means the authority. State is again Article 12. You know? What is state? What is state? 12. Definition. In this part, unless the context otherwise requires, the state includes the government and Parliament of India and the government and legislatures of each of the states and or local or other authorities. It does not, there was a case which came up as to whether the judiciary is a state within the meaning of Article 12 of the Constitution of India. Simply because the constitutional framers did not understand the concept that you don't have to write each and everything, brevity of expression. So, state. Now, when you read Article 14, the state shall not deny to any person, equality before the law or the equal protection of the laws within the territory of India. So, it's the obligation of the state to treat every person equally. If there is a discrimination, then the person has to approach the court of law and seek redressal of his or her grievances, and those matters have to be touched upon by the courts on a case-to-case basis. It cannot be on the basis of a thumb rule. You may say that this pattern amounts to discrimination. The court, while looking at the papers, may say that no, it is not discrimination. But that is for the courts to decide. It's the interpretation of that is why you have a judicial system. Yes.
Your Lordship, I have a question with regard to Article 21. So, given the recent judicial trend we've seen, especially after the Cooperative judgment and in the other matter, we've seen the judicial trend shift towards a reliance on Article 21. So, you've spoken about the soul of the Constitution today. I'd just like your opinion on how much of Article 21 constitutes as a soul of our Constitution.
No, it does not by itself constitute the soul. Basically, Article 21 has been interpreted and expanded. It is basically protection of life and personal liberty. And with that, privacy has also been brought in. Basically, this is a concept of liberty which has been borrowed from the United States of America to protect the individual's liberty and, of course, protection of life. I cannot say that the Constitution only talks about liberty and protection of life, and whether it is more important than the other, like I did today, deliberately did not discuss on Article 21 or 14 or whatever is discussed, because I consider that the Constitution cannot be read myopically. It has to be read in the manner in which the preamble says. Definitely, protection of life and personal liberty is a key segment of the Constitution. But what about the concept of federalism? Suppose the federal dharma is not honored, then there will be complete chaos. Each state will go and do its own things against the constitutional scheme. The center will send its paramilitary force to take over the law and order of the state, which again cannot be done because law and order is a state subject. So I would consider that Article 21 is important very significantly because of the fact that the Supreme Court and the High Courts have tended to expand its horizon, but it cannot be said to be the soul of the Constitution, or the heart and soul of the Constitution is in its preamble.
Thank you so much, Umanchu.
Sir, if you permit, last question.
Yes, last.
Sir, as you talk that High Court is the superintending this subordinate judiciary.
Yes.
It's, I agree. Because Article 214 says there shall be a High Court in each state.
No.
And also Article 131, 231 to 235. Sir, point is here that the Supreme Court and Supreme Court is appointing also the judges of the High Court and all the High Courts of the states. And particularly, I am talking about NJAC. What's your opinion that National Judicial Appointment
I
Commission?
need not express my opinion on NJAC because the Supreme Court has expressed its opinion in a judgment delivered by Justice Kehar, sitting with other judges.
I'm coming, sir. If you little permit, Justice Joseph Korea, who was the part and parcel of this judgment, and after his retirement, when he was given farewell by the Kerala Bar Association, he lamented. Not only once, again he also, when he came to the Bar Council of India, that again farewell was there, he lamented. I regret that striking out this NJC. So is it not a superintendence over the High Courts of the Supreme Court of India?
Well, Justice Joseph is entitled to his lordship's own opinion, and the Supreme Court is entitled to voice. That's why I say that a judge should only speak through his judgments. That's my personal view. That's why I do not express any opinion about any such matters, either in public or in private. I have disciplined myself. I have restrained. I will not, because if I have to express an opinion, I will express it through my judgment.
Right.
Thank you very much.
Thank you.
Thank you, Your Lordship, for your enlightening words and insights into the soul and structure of the Constitution. As a student of law, and if I may take the liberty to also speak on behalf of everyone present here today, it was a privilege listening to you, Your Lordship, as you highlighted the importance of really understanding the provisions of law, rather than just overemphasize our reliance on rote learning. And your call on the youth and the our young legal professionals to re-energize the significance on selecting litigation as a career pathway. Once again, Your Lordship, it has been an honor. I now invite Professor Chintamani Rao, head of the Department of Law, to deliver the vote of thanks.
Respected Honorable Chief Justice Vishwanath Samudar, the High Court of Meghalaya, and my Honorable Vice Chancellor Dr. S.K. Srivastav, and Pro Vice Chancellor Dr. N. Lami, and our beloved Registrar Dr. Joy Narayan Naik, and all the heads and deans of the schools and departments, and particularly Dr. J.J. Mojika, Professor of Department, who is the nodal officer of this program, and all the research scholars, students, and the people, those who are also joining through online. Very good afternoon to everybody. So thanks giving this opportunity to stand before you to offer my vote of thanks as a matter of that obligation. So at the outset, I express a very good afternoon to everybody, and particularly coming to Justice Somandar. So the university, on behalf of the university and the Ministry of
Higher Education, Government of India, and also UGC. I am here standing before you to offer the vote of thanks, and it is a great privilege on my part that Justice Somodar, who has enlightened and discussed very constitutional matters, and which he has learned and he has taught also. And sir, I particularly thanks to you coming to this university in a maiden Commonwealth, and also enlightening us in a very higher manner. And we will not forget you. And thanks for your knowledge and for contribution to you. Second, the thanks goes to our beloved Vice Chancellor, who has encouraged a lot organizing this excellence program and observing this 71st Constitution Day, and also to Pro Vice Chancellor, who has spared his time and also delivered a little speech on Constitution, and Dr. Naik also. So all thanks goes to the dais who has presided over and spoke over. And next I come to nodal officer also. I thanks to her because of her hard labor, tireless work, and this program to be able to success. And finally, I express my thanks to all these judicial officers who joined with us, and also the deans and heads of our different schools and departments, scholars, and particularly I thank also the media persons and our public officers. And finally, it is directly or indirectly who supported this program for this success. And once again, I extend my heartfelt thanks to each and everyone present here and outside the podium. Thank you.
Thank you, Professor Rao. Ladies and gentlemen, may I now request everyone to stand for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मांगे। गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।